morning. Welcome to the Appeals Court. Let me start by introducing the panel. To my right is Justice Ditkoff. To my left is Justice Brennan. I'm Justice Shin, and we will be your panel for the 4 cases we have on the list today. As I'm sure many of you are aware, the rules of oral argument are each side has 15 minutes to argue. You don't have to use all your time if you don't want to. If you choose to, when the yellow light goes on, it means you should start trying to wrap up your argument. When the red light goes on, your time has expired, and we do not allow rebuttal in the appeals court. The last thing I'll say is that the panel has read all the briefs, we're familiar with the record, and so I'd urge you to get to the heart of your argument. Okay, so I believe we're starting with case number 2, which is Commonwealth versus Lemaine, number 2023 P938. Attorney Conley.
Thank you, Your Honors. May it please the Court, Alex Conley on behalf of RYLAN Lemaine. In this case, 9 out of 10 times where there's an issue of an amendment that is a form amendment to the date of the offense, there wouldn't be prejudice in this kind of case. However, this is that 10th case of the 9 out of 10 cases because of the totality of the circumstances here, especially the admission of bad act evidence over time makes the diverse dates amendment actually come into play as relevant and prejudicial to Mr. Lemaine here. I don't think there's a substantial dispute. This wasn't a case that did occur on diverse dates. The allegations was a single date in March, a strangulation occurred, and assault and battery occurred. So I think that certainly the diverse dates language was not proper. The question then is, was there prejudice from it? And I think that's what the heart of this case is about. And I think there's a couple of factors that play into prejudice here. One factor I want to point out in particular is the acquittal on the strangulation charge. Often in these types of cases, especially prior bad act cases, the court could say, well, there's no prejudice because of an acquittal, because that shows the jury wasn't overly prejudiced toward the defendant. However, in this particular case, the acquittal plays a different way. Acquittal on one charge was the strangulation charge. The strangulation charge, the testimony as to the strangulation charge, was basically the testimony of the alleged victim, Ms. Gilmet, on this one particular day in March.
Counselor, could you tell us how the prior bad act issue is preserved?
So there was a motion in limine for the prior bad acts. The defense counsel moved in limine to exclude all prior bad acts.
That's not... Yes, about the rape of a child and rape or sexual assault accusations, which the Commonwealth said they weren't going to bring any of that in.
Right. So the Commonwealth moved to bring in specific certain allegations of bad acts, photographs, and a number of other instances. Judge Chan ruled, and I think ruled relatively well, in my opinion here, that no specific instances are coming in, just the general hostile relationship, which I'm not arguing is incorrect. The hostile relationship should have been admissible, but...
You'll agree that none of the specific incidents that the Commonwealth proffered came in? The elbow to the ear, the grab of the arm, or the shove where she hit her head and he grabbed her keys. Those 3 did not come in, correct?
Correct.
Okay.
Those specific instances did not come in.
So, I mean, if the judge ruled no specific incidents and the witness testifies specific incident, why don't you have to object or move to strike?
Well, I think that his objection was broad enough at the motion in limine stage. I said, I want no bad acts.
But he won the motion in limine. Grady says that a motion in limine protects when it's heard and denied, not when it's heard and granted.
Well, I think it was denied in part and allowed in part in this case.
But the only thing that was allowed was the hostile relationship, and that's not what you're objecting to. You're objecting to a specific prior act that the judge excluded.
Correct, the specific acts that were excluded. I take Your Honor's point. I do think that the objection at the motion limit stage is broad enough and that defense counsel was under the impression that, perhaps errantly, that the testimony was general enough that it wasn't qualified as those specific instances, therefore didn't feel the need to renew his objection to the hostile relationship. I suggest that may have been a mistake on his part because it was past just the hostile relationship, an abusive relationship. It was, this has happened in the past, this always happens this way, this is how we've done it before type situation.
But it's not unusual in a dynamic of a trial, particularly domestic violence type case for a victim to kind of stray a little bit off topic and start talking about things, right?
Right.
You're not suggesting it was the judge's job then to interject or sua sponte strike and instruct, right?
I think the judge could have had done that. I don't know if, I mean, certainly he's not required to in all circumstances.
What about the argument that it may actually bring attention to something that in the context of the overall testimony, not that the jurors would have missed, but it just, because this is really, I mean, I knew it was either going to continue and I should just hold my breath because that was usually when I would need to take whatever less breath I needed to hold it off. It's kind of an odd way of putting it, which I presume you would interpret as she's been choked a lot of times, so she knows what it's like. She's going to take a big breath. Although it could be, I'm like, here we go. So do you think that there's any sense at all that the defense attorney doesn't want to object here because what's that doing but shining a spotlight right on there, and then we're going to stop for the judge to give a limiting instruction which further focuses the jury on that, as opposed to just let it go and see where it lands?
It very well could have been his strategy. It's hard to say what his exact reasoning might have been. I do think that regardless of his preservation of the issue, I think there could still be substantial risk of miscarriage of justice in the totality here. I think that trial counsel wanted to highlight the prior backs not coming in, and may have been a strategic choice, as Your Honors mentioned, to not highlight it when it did come in because of the way it came in the heat of the trial, not wanting to bring attention to that.
Can I say the witness's testimony that the relationship was abusive, argumentative, and yelling? You're not suggesting that that is beyond the hostile relationship general, or the parameters of the judge's order?
No, I'm not suggesting that. I think that, as I said, Judge Chan was correct. A hostile relationship is admissible. I think in this case there was enough for that not to have been an abuse of discretion to introduce the hostile relationship.
What about the victim's testimony that the defendant was abusive, hitting, anything imaginable, sexual? Is that still under the general kind of, without getting into specifics?
I think that's on the line there when it talks about and sexual, and that's not really just a hostile relationship. If it's abusive and sexual, it might be saying this power backs, but I think it's still not the thrust of my argument, that one either. I think more is the kind of, and I think I put this in my brief as kind of, he testified how he usually responded by taking a deep breath and trying to dig her nails in, and that during such fights, Ms. LaRue would always stand by the TV. And then Ms. LaRue kind of doubled down on that when she testified here too, saying, yeah, I've broken up their fights before. They've had other altercations. I've broke them up. I didn't break them up this time. And then on many prior occasions, she'd seen Miss Gilmette's hair disheveled after they've met. So that's where it's really goes beyond general relationship to specific things that have occurred in the past.
Counselor, the complaint in the appendix still says 9/4/2019. Is there an actual amended one that someone's scribbled on?
I didn't see one in the file, Your Honor. I'm not sure if there was ever a written down amendment there, but I think what matters as far as the jury didn't see the complaint as far as...
As my next question is going to be, is there any reason to believe it was stapled to the verdict form or anything like that?
No reason to believe that. I think what they heard was what the clerk told them. What the clerk said is the complaint, the diverse dates.
We don't have the verdict slip, right? I looked, I didn't see it.
No,
So we don't know what was written on the verdict slip,
No, I don't believe so.
at least on this record.
So, again, in terms of prejudice, beyond the acquittal, which I think does show prejudice here, I think another thing that shows prejudice is the method, the theory of the case from the defense side as well also shows some prejudice. The theory of the case was somewhat focused on the dates, the confusion of the dates from Ms. Gilmette, saying that this didn't happen this date, which would have been a great theory if the jury hadn't been informed this could have happened on diverse dates in March. And once the jury thought, so why do they care about defense's argument about which date it occurred on or with her confusion about dates? They don't have to find a specific date. They have to find it happened on a diverse date. Sometime in March, there was an assault and battery that occurred. That's what they were went in with. And
Isn't that accurate, though? I mean, if it again had been amended correctly to on a date in March or on or about in a date in March, it's still the essence of right, that we don't know what date it was, but it was some date, and in fact, it might have even been late February, based on the testimony, but...
If that had been the amendment to a date in March, and then they tried to prove the case using a number of prior bad acts to make those dates in March, that would be a substantive amendment at that point. It would no longer be a form amendment that could be permissible. I think the focus here is that it did have to be this event that the defendant had notice of being charged with, not other events that could have happened before. Additionally, as far as the credibility of Ms. Guillemette and how the jury may have considered that, I think that's another thing with the strangulation acquittal, that there was some question about her credibility in that sense. And where Ms. LaRue testified also to the prior bad acts, but didn't have the direct testimony as to the strangulation, it shows that that could have been what the jury credited. And that's also relevant to the Ms. Guillemette's was questioned for credibility. There was a prior trial where she admitted to having testified at a prior trial to being biased and prejudiced against Mr. Lemaine. So it's very likely the jury could have said, well, she's not credible, but this other witness, who's presumably more credible, she also says something happened sometime. There were other fights. There was something that happened on a diverse dates in March. So again, with that amendment in mind, the jury's possibilities was opened up, and they could find that in any of those senses. So basically, the final point I want to make about the prejudice here is as far as the lack of jury instruction. Clearly, the defense counsel may have had a good reason not for suggesting a jury instruction, not for wanting to bring attention to it. However, where the jury was left with, at the outset, this occurred on diverse dates. Now we've heard through testimony about many different assaultive behavior throughout a lengthy period, and they're not instructed how to use that evidence in any way. The only bad act type jury instruction that's given, it relates to the restraining order, and they say don't use the restraining order for purposes other than the fact that it existed, not relevant to the charges, which isn't part of my argument at all, but instead the jury just heard, here's all these acts, you have diverse dates to choose from, go for it. So I think in that case, and that's why this is, like I said, 9 out of 10 times the amendment saying diverse dates wouldn't be an issue, but this 10th time it is an issue because of those reasons. Unless the panel has any further questions, I'll rest.
Thank you, counsel.
Thank you.
Good morning. May it please the court. Marina Moriarty on behalf of the Commonwealth. Your Honors, any error in amending the date on the complaint did not create a substantial risk of a miscarriage of justice because the jury was aware that the Commonwealth alleged a single incident of assault and battery and a single incident of strangulation. It's in my brief, but I'd just like to highlight that the jury only heard
A
the
single, like, act or a single sort of time?
I'm sorry, I missed the first part.
When you say a single incident, do you mean like a single act or do you mean like a single episode?
I mean a single episode.
Okay.
Right, so an incident, and I think that's how all the parties kept referring to it, an incident in March, on one night in March. And the jury only heard the words on diverse dates twice at the very beginning of the trial, just after they were sworn in and prior to opening statements. So I would suggest that those very archaic words really had very little meaning for the jury at that point. And from then on, they were given an opening statement that focused on a night in March by defense and the prosecution. The witnesses all testified to the very specific details of what happened on this night in March. And then in closing, again, both counsel referred to one incident, a night in March. And in closing instructions from the judge, there was no reference to any diverse dates or any need to come to any unanimity on a particular date. So for those reasons, I would suggest that there was no substantial risk of a miscarriage of justice here. And just with respect to the general prior bad act evidence, I would suggest that this is, kind of standard run-of-the-mill prior bad act evidence that's admitted in many of these kind of awful domestic violence kind of relationships where there is a history of this kind of behavior between the parties. Judge Chan carefully found that several specific incidences were unduly prejudicial. He found that one was too remote in time, and he just allowed the general nature of the hostile relationship.
Well, it was the hostile nature of the relationship. He certainly didn't say, well, kind of any general abusive stuff, yeah, that's fine. Just don't talk about these three specific things. Fair?
Yes, Your Honor. And
So to what extent do you think that the particular testimony that Mr. Conley has identified about, I knew it was either going to continue, I should hold my breath, et cetera, is that in violation of the judge's specific order, or is that just, again, the victim talking and testifying about things that neither party necessarily particularly anticipated?
I think that is just something that I'm sure that the prosecutor instructed the witness not to testify about the specific instances, but said you can testify about X, Y, and Z, and then the civilian witness obviously took that kind of a little bit further. I would agree that I would concede that there was an objection to the hostile act decision with respect, because I checked, defense counsel did lodge an objection to the Commonwealth motion in Lemaine, so I think that that would cover the specific hostile act, but I still think that defense counsel, when
Well, but except the judge grants, rules for the defense on those acts. Grady isn't just about making a motion, it's about making a motion and the defense losing it, then you don't have to make the objection again. If the defense makes the motion and wins, and someone violates that, they have to object, don't you think?
I think in this constellation of facts, Your Honor, I think that he won 90%, but the Commonwealth won the part of the motion that would have allowed in evidence of a hostile nature. But where these statements arguably went beyond the judge's rulings, I think it would have been incumbent on defense counsel to object at that time to preserve his specific objections to what went beyond the judge's rulings. And I understand that it might have been
So you're saying it is preserved or not preserved? I'm not sure I'm clear on that.
I don't think the specific statements that the defendant is now contending are problematic are preserved.
Okay.
Because there was no objection contemporaneous with those statements that arguably went beyond the judge's ruling. But regardless, whether it's a...
Can I ask, did you listen to the FTR on this or just read the transcript?
I did not listen to the FTR.
All right, because there was clearly a conversation about instructions just as they were coming back from lunch, and it talked really more about the 209A violation. It's just unclear to me whether there was a broader conversation about an uncharged misconduct limiting instruction. Clearly wasn't given contemporaneous with the testimony, but whether that should be part of the judge's final instructions. Nothing more than what we have here, I take it.
Nothing more than what we have here, Your Honor. And there is a written decision with respect to the motion to eliminate, which is parallel to his decision from the bench. I would just finally suggest that there, again, there's no, I think that there's a reason to believe that this jury, or there's no reason to believe that this jury was unduly prejudiced by some evidence of a hostile nature of this relationship, particularly where there was extensive cross-examination about the victim, her failure to immediately report the incident, her failure to report the incident when she filed a restraining order, and then why she ultimately reported the incident 6 months later, and then again why her friend, then girlfriend, never reported the incident to the police. So I would suggest that neither the amendment with respect to diverse dates nor the statements that arguably went beyond the judge's ruling were amounted to a substantial risk of miscarriage.
Do you think it was incumbent on the judge, or at the very least, maybe a better approach to not necessarily right when the question was asked and answered, or when it was just offered, I suppose, by the victim, wait a few questions and then bring the parties up to sidebar and just ask the attorney, do you think you might want an instruction on this, a limiting instruction on that evidence we just heard, or do you think that's completely up to the lawyer to object and to make a record there?
I think that's entirely within the judge's discretion, Your Honor. I think I could never see a reason why a judge wouldn't want to do that.
You understand why they might not do it right after the question was asked?
Of course, for the same reason why the defense attorney might not object.
Right.
But I think at a natural break in time or at any point, particularly, even in this case, when they were discussing jury instructions, the judge could have and maybe should have raised the issue sua sponte.
Okay.
If the, Your Honors have no further questions, I'm happy to rest on my brief.
Okay, thank you very much
Thank
to
you,
both of
Iris.
you. The case is submitted. I think we're going to move on to case number 3, which is DDS Industries, Inc. versus Leftfield LLC, number 2023 P511. Counsel.
May it please the Court, Your Honors, my name is Elise Kuhn, and I represent DDS Industries today. The matter substantially before the Court is in regard to a letter published by the appellee in this matter that stated in relevant part, DDS was responsible for most of the quality issues on a public construction project. DDS was only marginally qualified to perform the work for which it was subcontracted, and DDS was only awarded the work because it was a local Fall River company. My argument will focus on the following points. My initial focus will be on the second prong of the standard set forth in Bristol Asphalt, as that analysis is dispositive, where the lower court properly held that the statements made by Leftfield were devoid of any reasonable basis in fact or law. The lower court, however, erred as a matter of law in determining that DDS had not met its burden to demonstrate actual injury as required under the anti-SLAPP statute. My final point will be in regard to whether the defamatory letter, which was made in a business context, constitutes protected petitioning activity. Bristol Asphalt was decided in January of this year, and it resettled the framework for deciding an anti-SLAPP statute. It also set the standard of review as de novo. Specifically, the SJC returned to the standard set forth in Duracraft and determined that the framework is twofold. First, the court must determine if the challenge count has no substantial basis in conduct other than or in addition to the special motion proponent's alleged petitioning activities, which I will address in a moment. And if the court determines that it has no substantial basis other than the petitioning activity, then it must determine if the statement was devoid of any reasonable factual support or any arguable basis in law. In this case, the court correctly determined that Leftfield statements were devoid of any reasonable factual support or basis in law.
Well, the court determined one statement out of a long letter didn't have a basis. Is that enough for the petitioning activity to have one little part of it not have a basis? Or do we look at the petitioning activity as a whole?
Yes, Your Honor, one portion is sufficient. As the court found in Bristol Asphalt and then further set forth in Columbia Plaza, the court is no longer in the action of parsing counts. The count must stand or fall based on the petitioning activity, or in this case, the defamatory statement. We have alleged a defamatory statement. The court found it was a defamatory statement, and the count must stand for that reason.
I didn't see in the complaint where this particular statement was identified as defamatory. The other two were.
It was referring to the letter in general, Your Honor, and so
Right, but
that
in the
instance-
defamation context, you have to identify the statement with particularity, and this particular statement was not identified. And so I'm not seeing why we're even looking at it on the anti-SLAPP.
Your Honor, then in that instance, the other two statements that are set forth are also sufficiently devoid of any reasonable basis in fact or law as far as the marginally qualified and whether or not DDS was substantially responsible for the delays on the project.
Okay, I didn't want to cut you off. You can continue with the initial statement if you'd like. Well, in relation to that, so the standard for showing some petitioning activity to be devoid of factual support is almost akin to frivolousness, maybe not quite that high. So this statement that your client was only kept on the list because it was a Fall River company seems to me to be somewhat vague. So how does that meet the standard of devoid of factual support?
I think that the court can look to the equal footing principle in Massachusetts public bidding and the necessity of determining that each bidder must stand or fall in equal footing, and where the location of a company is nowhere in the bidding statutes, it would suggest that it would go to the equal footing principle, Your Honor, that where you work would then determine whether or not you're qualified to bid on a project where that has no reference in the statutes.
Can't it be read as saying that your client only meant the minimum score because of these references, one from a Fall River project and two from, I think, pretty close by? Why can't it be read that way?
That's not what it says, Your Honor.
Well, that's why I'm saying it's somewhat vague, right?
Respectfully, I disagree with you, Your Honor. I think that it says that they only got this because they were a Fall River company, and that states that the location is the basis for their qualification.
So Jim Rogers' affidavit says that DDS nevertheless remained in contention for the project because of its experience as a Fall River-based entity. Why isn't that a basis that makes it not devoid of factual support?
Can you please repeat the question, Your Honor?
The Jim Rogers affidavit says that DDS remained in contention for the project because of its experience as a Fall River-based entity. Why isn't that some factual support making the petitioning activity not devoid of factual support?
It doesn't matter that it was a Fall River-based company. It matters what projects it successfully completed, and that is what the pre-qualification report requires. When you're pre-qualified for a project, you have to list generally comparable projects. And so in this case, maybe the comparable projects were in Fall River, but they could have listed projects if they had performed them in Waltham, in Woburn, just like any other company. The fact that they were in Fall River wasn't the consideration for pre-qualification.
Well, but to say that there is counter evidence to the evidence that this statement was based on doesn't prove it's devoid of factual support. It just shows there's two ways about it. But if that's true, why wouldn't it be an anti-SLAPP dismissal?
I think, especially where the lower court already determined that there was no reasonable factual basis, and again, it's not in the statute. And that's similar to the cases that are cited too in Bristol Asphalt, where they looked at whether or not petitioning, someone who was searching for a TRO had listed 3 items or causes of harm, and they said, no, you didn't get to 3, that's not, whether or not there could have been some basis, there's a legal standard, it wasn't met. And in this case, you have the inverse. There's a legal standard for pre-qualification, and it was met by DDS. And it has nothing to do, and it shouldn't have anything to do with the location of the company.
You argue that the record is clear that Littlefield falsely claimed that DDS was only marginally qualified, right? The qualification is 70, and DDS at a 74.8. Like, why is that factually incorrect? Why is that not an actual marginal qualifying score?
I think, well, one, they shouldn't have released that information in the first place because it should have been confidential, whether or not they.
Why is it confidential?
Right,
I didn't understand that.
No, that's my question.
I didn't understand. Both sides seem to agree it's confidential, and I don't see anything that says it's confidential.
It's my understanding from the statute, Your Honor, that the scores for pre-qualification are not to be released by the awarding authority.
I didn't see it in the statute. It says they're not public records, but public records law just tells you what you have to disclose, not what you can disclose. Is there some other part of the statute I'm missing that says that they can't be disclosed? Or is it just this, it's not a public record part?
I don't have that information for Your Honor.
Why is it relevant whether it's confidential or not with respect to the anti-SLAPP?
I think because when you're talking about pass or fail, right? So if you have an attorney who passed the bar, you could go get your bar score, and then you would know what it was. But generally speaking, it is kept confidential. No one else can go out and find out whether or not you passed the bar. It is pass or fail.
And if you're saying, well, the attorney passed, but kind of only marginally, you might want to look to someone who got a 90, not a 74.8. Is that a problem?
I think it should be, Your Honor. Yes.
Okay.
I mean, confidential or not, we're looking at whether it's devoid of factual support. So if it's 74 and the minimum is 70, why isn't marginally qualified an accurate description?
Because there is no marginal when you're talking about pre-qualification. You either are or are not. It's pass or fail.
All right.
As far as the reasonable basis in factor law, unless your honors have any further questions, I'll move on to my second point. Thank
About the
you.
damages? Can I ask you a question about the damages?
That's where I'm going. Yes,
Good,
Your
all
Honor.
right.
Excellent.
So damages presumably were sought, I believe the complaint said, to redress an economic harm, not to prevent one, right?
I'm sorry, can you repeat the
Yeah,
question?
the complaint seeks damages presumably to redress some economic harm. That's what damages usually are there for.
Typically,
Okay. So can you talk about how the complaint would have prevented economic harm to the business? How is it prevented from occurring in the first place?
well, Your Honor, I'm not sure if this is going to directly address your question, but I think that there's one initial thing that we need to approach here, which is the difference between injury, which is set forth in the statute. You have to prove actual injury and actual or special damages. And the lower court said that we didn't find actual damages, and while there may not be specific quantifiable special damages, what the statute says is that you need to show actual injury. And I think that if you look at the cases, which the court rarely gets to, whether or not there is actual injury, they're actually quite lenient in determining whether or not injury has been sustained. And in this case, DDS has alleged defamation per se. They have asserted by affidavit that their goodwill and their reputation have been damaged. That is an actual injury. And I believe in Van Loo, but
You have to show actual injury. Just saying DDS suffered damages in the form of loss of business, negative impact on its business reputation, and loss of goodwill, is that really showing it, or is that just asserting it?
both, Your Honor, in this case, because it is defamation per se, which carries with it a presumption of injury. So the burden before the court is whether or not they have sustained this by a preponderance of evidence, and where the statute itself, defamation per se, carries a presumption of injury, we have certainly met a burden of it being more likely than not, especially after asserting by affidavit, after the lower court found that it was a defamatory statement, that we suffered an actual injury in the form of.
So any business defamation case would automatically satisfy the actual injury requirement? Is that what you're arguing?
As long as it is defamation per se.
Well, isn't that what you're saying, that defamation in the business context, damage to reputation and goodwill in the business context is defamation per se? That's what you're arguing, right?
Yes, which we also asserted and supported by affidavit.
So any business defamation case would satisfy the actual injury requirement?
Yes.
Okay. That issue's not been decided in the Commonwealth, right? Have you found a case that addresses this? Okay.
No, Your Honor. And again, I would point to, there was, I would have to look at the case specifically, and I apologize, but there's at least one case which is mentioned in Bristol Asphalt. I believe that it is Van Loo. No, it was Sudduth. Sorry, S-U-D-D-U-T-H was the defendant in that case. And they said that she had supported her claim for actual injury because she did show economic harm, but they also noted and looked to the fact that she submitted an affidavit from her social worker showing that she had suffered, it was essentially emotional injury. And so the court had also looked to that, this extra, not just special damages, but actual injury as far as what that could be for harm to goodwill or emotional, mental harm.
So in your brief, you say that your client has been rejected from other pre-qualification, that other pre-qualification submissions have been rejected. Is that in the record or not?
I don't know that it's further in the record. I know that under defamation, one of the allowances for a defamation claim is that if damages continue to accrue through the course of the proceeding, that
Right,
is
but
allowable.
this factual assertion is not in the record anywhere, right?
It's in the brief, but not further in the record, Your Honor. We would be glad to submit an affidavit to the lower court or to otherwise assert that now that we have moved farther along and have additional proof of damages.
Well, we're here on appeal, so, yeah.
I think the court had,
Your Honor.
I think the Superior Court has to rule based on what was given to the Superior Court at the time.
I'm sorry, Your Honor?
I think the Superior Court judge had to rule based on what was given to him at the time.
Yes, Your Honor. You could remand for further fact-finding if you so chose, but I believe that, again, where we have the defamation per se and we have the affidavit from Mr. Sylvia showing that his business was harmed, that we have met the actual injury, not damages, but injury standard set forth under the anti-SLAPP statute. I see that I'm low on time. I have not gotten to the petitioning portion of the argument. I would quickly say that where Leftfield was serving as the owner's project manager, this letter is essentially to his boss. They were worried about getting fired. That's in the record, that's in the briefs. And the court could consider this commercial correspondence as opposed to petitioning activity, which would also defeat the special motion to dismiss. I would respectfully request that the court reverse the trial court's order allowing the special motion to dismiss and vacate the judgment. If you have any further questions.
Okay, thank you, counsel.
Thank you, Your Honors.
Good morning, Your Honors. May it please the court, my name is Sean Laughlin on behalf of the appellee, Leftfield, LLC. This court should affirm the dismissal of plaintiff's complaint because plaintiff wholly fails to satisfy the shifting burden placed upon it under Chapter 231, Section 59H. But taking this case in the overall context, with respect to viewing Leftfield's letter as an act of petitioning, I think it's important to note that one of the cornerstones of anti-SLAPP statutes, they exist in nearly every state across the country, is it harkens back to the decades-old doctrine that...
But ours is quite unusual.
Pardon?
Ours is quite unusual, quite a bit.
Certainly, but there are
Vigorous.
some states that do adhere to a very similar statute. In fact, Justice Shin asked a question before about whether or not the Commonwealth has addressed damages per se in the context of our anti-SLAPP statute. It has not. The state of Maine has, though, however, and the state of Maine ruled in 2008 in Schelling versus Lindell that damages per se are insufficient to serve as actual injury under Maine's anti-SLAPP statute, which is very similar to Massachusetts in its language. To get back to my point, though,
Was that in your brief?
that was not in my brief, though. It was in trying to find desperately a case where we address this very issue, and I believe that's why Justice Shin had raised the question, because I believe both parties have been trying for some time
Give me
now
the
to find a case
citation,
on that.
please.
Pardon?
The citation, please.
942 Atlantic 2nd, 1226.
Thank you.
Certainly. The response to speech that the listener believes to be negative speech that enters the open marketplace should be met with more speech, and it should not be met with civil litigation. And that's precisely what Leftfield did in this scenario. Faced with a inflammatory, accusatory Facebook post published by plaintiff's owner to a newspaper with thousands of readers and social media users online that alleged conspiracies, cover-ups, attempts to deceive taxpayers, and, throws out allegations that city officials were in the back pocket of the construction manager, Leftfield picked up its pen and wrote a letter to the mayor to try and set the record straight, to try and tell its side of the story, to try and explain why the source of these allegations perhaps is not entirely credible given his involvement in the project issues, and try to protect itself and protect members of the project team by explaining what they were doing to resolve the issues on the project. Having met with that opposition in the marketplace, plaintiff did not meet it with more speech. Instead, it resorted straight to civil litigation. And that's precisely the type of scenario that the anti-SLAPP statute exists for. That's the type of case it seeks to protect. Plaintiff argues that this is not petitioning because it argued in the Superior Court that this is not the type of case where the anti-SLAPP statute is utilized. But we've gone well beyond the typical David versus Goliath, small property owner trying to be heard at a zoning hearing with some big corporate developer that shuts it up with civil litigation. We're well past that. The anti-SLAPP statute's utilized with two private property owners, two competing corporations, employer versus employees, and Leftfield submits that two project participants on a public construction project is a factual scenario where one could be found to be petitioning. And so this case actually does fit within the concept of anti-SLAPP. Moreover, there is no legal authority, contrary to plaintiff's assertion, that a reply to speech that's out in the public sphere cannot be deemed protected petitioning. In fact, I think North American Expositions Company versus Corcoran states the exact opposite. At page 871, the court stated there that a letter written in response to the special motion opponent's prior testimony in front of a legislative body was protected petitioning. It was, quote, petitioning activity that falls squarely within the scope of the statute. And third, on the petitioning issue, the fact that Leftfield possessed a contractual relationship with the city of Fall River is insufficient to take it or preclude it from being able to petition the government. Leftfield contends that that argument was not raised in front of the Superior Court. It's been addressed for the first time here on appeal, and it's improperly preserved. But to the extent this court wishes to consider it, that argument that plaintiff advances relies on a misinterpretation of Coburn v. Gasfriend from 2005. That case stands for the proposition that the government may not petition itself. That's straightforward, that's clear-cut, and Leftfield doesn't have an issue with that ruling. That makes sense. That's not what occurred here. Leftfield did not write this letter for the government or the mayor of Fall River to then take it, adopt it as his own, and use that as the city's position against plaintiff. In fact, the record shows in the news articles attached to Mr. Rogers' declaration, the mayor issued his own press release the day after the Facebook post. And the mayor issued his own press release after meeting with the director of capital improvements, after meeting with corporate counsel. It didn't rely on Leftfield in any way. Whereas in Coburn, you had the state police hiring a physician to serve essentially as an expert witness, completely disinterested with no relationship to the person being accused, who submits an affidavit rendering his expert opinion that the state then takes and adopts as its own in a prosecution. That's the government petitioning for itself. But Leftfield here is trying to protect itself and protect its project team members. And so,
Maybe you should move on to the injury issue. That seems the most interesting.
certainly, I agree with Sister Counsel that there is a distinction between actual damage and actual injury, and perhaps the papers before this court and before the Superior Court use them interchangeably without acknowledging that distinction. As the Superior Court aptly noted, loss of goodwill or reputational harm can in certain instances meet the definition of an actual damage. But the anti-SLAPP statute requires a showing of actual injury. And I think that there's an important difference there because the actual injury is, or the injury that is being shown, is really the manifestation of the damage. How were you damaged? And so a lot of the cases where we do reach the second prong of the shifted burden, all of those special motion opponents that satisfy the actual injury requirement show how. So in the Vitan's case that Sister Counsel cited, for example, yes, there is a declaration from a therapist explaining how the special movement's conduct in stopping the development of her private property for a decade manifested itself in emotional
Well, so
harm.
you would agree there's enough here to get past a 12B6 motion, right, as far as the allegation of damages?
Yes, Your Honor, and
Okay,
we
so
conceded that in the Superior
Why
Court.
does it make sense to have a different standard in the anti-SLAPP context?
I think it makes sense. There is a contention of policy in that regard, but I think it makes sense because the purpose of the anti-SLAPP statute is to protect someone from exercising their First Amendment right, the right to petition.
So let's say the letter had contained a false accusation of criminal activity. That would not constitute actual injury?
I think it would depend, well, first off, you would meet the first prong if it was false, right? Because it was
All right, so
devoid-
just on the actual injury. So it's defamation per se, just as your friend is arguing that these statements are defamation per se.
Understood.
What additional showing do you need to make?
I think in that instance, there needs to be a how. So with the false criminal allegation, if that, for example, I believe it was in the first time that 477 Harrison versus Jace came up on appeal, I know it came up twice, there was a criminal complaint filed in that case, and the special motion opponent had to appear at a probable cause hearing, presumably with counsel, which caused him embarrassment and emotional distress, defended himself, and eventually the criminal complaint was thrown away because there was no probable cause. That, placed in an affidavit, was sufficient enough to show the evidence of actual injury. That's the manifestation of the emotional harm that was alleged in that situation. Similar to in Van Loo v. Stansfield, that was where the harassment order was issued against a fellow politician in Chelmsford, and he had to appear after the ex parte ruling, defend himself in court, and explain why there was no basis for the harassment order to be
So a
granted in the
business
first
has to
place.
wait until after they suffer economic loss before they can file a defamation case?
Not in every instance, Your Honor, but I think with respect to when petitioning is at
Right.
issue, I think that that is a concern, yes, because the statute is trying to avoid retaliatory litigation. So if someone is exercising their right to petition and is immediately met with civil litigation, that's precisely the situation we're trying to avoid. So in this unique concept, or in this unique context, I think there is a scenario in which one has to show that the protected petitioning was otherwise devoid of factual or legal support, and that it manifested itself with an actual injury. Because otherwise, it is simply suing someone for the purpose of protecting, trying to chill one's speech. I understand that Blanchard has since been abrogated, but it is trying to sue someone to get them to stop petitioning. It's not really to redress harm that has already taken place.
Could I ask you a question about the statement about DDS was only kept on the list because it was a Fall River-based company? You argue that Section 8E grants the awarding authority discretion to how to award the points, including what weight given to references. I'm not understanding that. Could you explain?
So, yes, Your Honor, I believe that the way the public bidding statute is set up, that there is a minimum threshold of 70, and that within each subcategory, there are certain amounts of points that can be allocated to eventually get to 70. And then subsection E provides the awarding authority, like you just said, discretion on how they want to weigh the points or allocate the points.
They have discretion within each subcategory, right? So the references can only count for a maximum of 25 points no matter what, right?
Understood, yes.
Okay, and so they have 4 references. You're saying that the awarding authority has discretion to give more points because one project is from Fall River? I don't understand, because underneath the 4 references, there's a breakdown of how they're rating DDS, and it seems to line up with the overall score. So I'm not seeing where the discretionary aspect plays into this.
So I think that there is some information within this bid qualification process that perhaps is not disclosed here, but if one looks at the breakdown of the reference points being provided across the board, DDS, for example, has 3 4s and a 3.8. Others had scores upwards of 5. Some had 0. Some had 2. There's a rating process within each reference and the weight being provided there that's not disclosed in this.
I mean, the scores are what they are, right?
Understood.
So how does the awarding authority have any discretion to give more weight to these scores?
Because the awarding authority would be the entity that is placing the score on the reference. So as respect how someone got a 4 when they spoke to a, Bristol Community College, for example, with respect to plaintiff, it's not clear from the trade qualification score sheet exactly how one grades.
So the breakdown underneath is done by the awarding authority, not by the reference?
Bear with me, Your Honor.
The 9 questions that are underneath the reference scores?
No, I believe those would be in the trade qualification score. Those are included within this.
No, but who's writing those scores down? Is it the reference or the awarding authority? It's the reference, right?
I believe so, Your Honor. I don't have that answer for you right now.
Again, it's not clear to me how the awarding authority has any discretion to put more or less weight on any particular reference.
Understood, Your Honor. But I think there's still factual support, and that's the important point with respect to that statement within the anti-SLAPP statute, is that it has to be devoid of reasonable factual support or an arguable basis in law.
Was the BCC New Learning Center project, was that in Fall River? I know BCC's got a few different locations.
So I had to look that up as well, and I understand that BCC has a Fall River location. It does not state on this form which of those locations it was, but at least one of the 4 references was located in Fall River. And you have Fall River, New Bedford, Taunton, and then a Bristol Community College location, all localities and municipalities within southeastern Massachusetts, compared to the other potential bidders that had substantially more high school experience, but Worcester, Wilmington, Framingham, Abington, Plymouth, Marshfield, these are locations that are not in this same region. In fact, plaintiff was the only entity that had an entire list of project references that were located in this precise region. And I think the larger point with respect to this one comment, and I want to make two remarks real quick, is that the standard, as you noted before, is akin to frivolousness. I believe Justice Brennan was on the bench during the RYLAN opinion in July when that was stated. And here, there is no showing that the statement itself is frivolous. It has a reasonable person could read it and see that it has factual support. It's a no reasonable person standard, which is quite exceedingly high to meet. And lastly, Your Honor, for the foregoing reasons, we believe obviously the other two statements were amply supported by the record factually and legally. And given the complete lack of any actual injury, we ask again that you affirm the Superior Court's order dismissing this complaint.
Okay, thank you, counsel. Thank you both. The case is submitted. Okay, we will proceed to the first case on the list, which is Commonwealth versus Henderson, number 2023 P944. Whenever you're ready.
Good morning, Your Honors. Attorney Dana Gravina on behalf of Andre Henderson. There are four arguments that Mr. Henderson raises in his appellate brief for why his conviction in this matter should be reversed. The first issue involves trial counsel's failure to request a reasonable provocation instruction at trial. This was raised in a motion for new trial where trial counsel did testify in an evidentiary hearing. And following that, the motion judge found first that Mr. Henderson was not entitled to a reasonable provocation instruction in this matter, and that's where I'll start. Mr. Henderson clearly was entitled to a reasonable provocation instruction here. It's important to note from the outset that the standard is that we have to view the evidence in this matter in the light most favorable to Mr. Henderson.
Assume we agree with you on that point. Talk a little bit about the strategy, if you would. That, to me, I just don't see how this is different than Glover.
It's entirely different.
Okay.
First of all, this is not a situation where trial counsel pursued an all-or-nothing strategy of, I'm going for self-defense, and if I lose on self-defense, then, so be it. I'm not going to go after any sort of manslaughter, fallback position, it's self-defense or nothing. And that's the key factor here. And how do we know that that was the case? Well, number one, trial counsel did request an excessive use of force in self-defense instruction.
Any good lawyer's got to have at least a little backup plan, right?
But that's a bad backup plan here.
Okay.
And the reason that that's a bad backup plan here is that trial counsel knew after the evidence was in that this was not a self-defense case. He knew it. He states in his argument for required finding of not guilty that this is a spur-of-the-moment, heat-of-passion shooting. He states that. He then goes on in his closing argument to not argue self-defense, to not argue excessive use of force
I don't
in
get that.
self-defense.
The Commonwealth has to prove here today, beyond a reasonable doubt, that my client did not act in reasonable self-defense on June 26, 2017. And then at the end he says, I ask you to find my client not guilty because he did not use reasonable self-defense.
2 times in the entire closing argument, he uses the term self-defense.
Beginning and the end.
2 times. And even the motion judge at the initial, at the motion for new trial hearing, stated at the conclusion to the Commonwealth, I've read this closing argument at least 6 times. Certainly sounds to me an awful lot like reasonable provocation. And that's clearly what he's arguing. At one point during his closing argument, trial counsel specifically states,
Counsel, just to call you a little bit on that, I'm looking at the closing where he said he started drinking a bit just to calm his nerves. He was extremely nervous and scared. I mean, he says self-defense at the beginning, self-defense at the end, and then he's maybe hedging it a bit, but it seems to me that those are all at least small points that would lead one to say he's apprehensive, he's scared, he's nervous, and then the guy lifts his shirt, and there we have it.
all of which are consistent with arguing reasonable provocation. The scared, the nervous, that's reasonable provocation. He's arguing reasonable provocation. He's not arguing, he is not pushing the jury to come back with self-defense. And
If he pushes reasonable provocation, he's doing a 20 minimum mandatory, right?
Absolutely. Better than a second-degree murder. Absolutely. And trial counsel at one point says, in his closing argument, and the motion judge makes a similar statement in a footnote in his decision. Trial counsel says that he did not have the intent to kill. That's what he argues. He says he did not have the intent to kill. That is not self-defense. Self-defense is an intentional killing. That's what it is. It's intentional killing out of the calculus of survival. At no point in this closing argument is defense counsel arguing that that's what happened here. He's arguing the exact opposite.
If you use deadly force to protect yourself, but you don't want to kill the person, you don't have the defense of self-defense? I've never heard that before.
Well,
If you shoot someone in the leg, say, to keep them from attacking you, wouldn't you still have self-defense if it killed them?
I'm sorry, say that again, Your Honor.
You shoot someone in the leg because they're attacking you, and they wind up dying, wouldn't you still have self-defense as a defense?
That's not the argument that counsel's making. That's not what he's saying. He's not saying he shot him in the leg, he didn't intend to kill him. He's saying he didn't have the intent at the moment to kill this person because he didn't have intent, meaning he didn't have malice, which is reasonable provocation. That's what he's arguing. He uses the term mitigating factor 4 times in his closing argument. Mitigating factor being reasonable provocation. Even defense counsel admits that he should have asked for this instruction. He admits, I made a mistake. He says, I did view self-defense as the weakest defense that I had. If self-defense is that weak, then excessive use of force in self-defense is that weak.
Could you clarify something you said at the beginning of your argument, that we know counsel did not go for an all-or-nothing strategy because why?
Because he asked for a manslaughter instruction.
Yeah, but that was also the case in Glover.
But again, you have to, that's one part of it. The next part of it is you have to read the closing and actually understand what is he asking the jury to do. He's saying, come back, he's saying there's mitigating
He
factors.
says, I ask you to find him not guilty.
Not guilty of murder.
It just says, I ask you to find him not guilty.
Correct.
I've definitely seen people come up and say, find him only guilty of manslaughter. That's not what he says. He asks for not guilty.
Because, and this goes to the illogical nature of what trial counsel did. Trial counsel did not ask for a reasonable provocation instruction. He then argued reasonable provocation to this jury. That is the tenor of the closing argument. I don't know how, even the motion judge said, I read this at least 6 times. It's reasonable provocation.
Motion judge said he wasn't entitled to an instruction, so I'm not sure how we take that to the bank.
Afterward, when he changes his mind. But again, he was wrong on a lot of things, that being one. But
So he talks about the threats in his closing, trial
Correct.
counsel. He says you have to take into consideration the relative size of the people. He was 6'3", 313. My client was 5'9", 180. Those are all the arguments you hear in self-defense, it seems to me. My guy's afraid. This guy's huge. My guy's tiny or medium-sized. Those are all self-defense arguments. And again, I think hindsight criticism of someone who's got a really tough argument and is hedging bets a little bit in a world where it's a rather nuanced difference, right, between reasonable provocation, excessive force, and self-defense, and all the other. I mean, that's a pretty nuanced difference. And can't we infer that he's going for not guilty, he's going for the whole thing, but he's also figuring, I got to at least put something in there to cover it.
Going for everything is not arguing mitigating factors. Mitigating factors is not going for everything. He says it 4 times. He's not arguing self-defense. He is arguing reasonable provocation over and over and over again. And he tells us, initially in his affidavit, he says, I didn't have a strategic reason. Then he says, my strategic reason was I didn't like the mere words language of the instruction. But then he doesn't go on to explain how that affects his self-defense case at all. He makes no mention of how that weakens a self-defense case. And the reason
Not in his affidavit, but in his testimony, he says, because he doesn't want the mere words instruction, because, frankly, his self-defense is pretty word-based.
No, he doesn't. He does not say that's why. He just says, I didn't like the wording mere words. The court goes on to say that he did that because it affected the self-defense instruction. But at no point did trial counsel ever make that point in his testimony. That comes from the motion judge, not from the testimony of counsel.
It was a tough call. There was some language in there about, threats or abuse language. Mere words alone are not sufficient to use deadly force. So I had some concerns about that language.
Correct.
That's what he testified to.
As it relates to reasonable provocation. But he doesn't say, I had concerns that that was going to weaken a self-defense claim. At no point does he make that point at all. And trial counsel knew.
Well, he says in the next page, I made a decision, I guess in retrospect probably wouldn't have, but that language, the mere words, might have hurt a little bit more than it helped. Must be talking about the self-defense there, right?
I don't see that's him talking about self-defense at all. I think if he was talking about self-defense.
Well, how would it hurt more than help unless he's talking about his other defense?
Or he's talking about reasonable provocation, which is what I think he's talking about. I don't understand how a mere words instruction can affect, on reasonable provocation, could possibly affect a self-defense instruction, which is a totally different instruction because it's a totally different defense with totally different wording.
You can't see how you wouldn't want a jury thinking about mere words are not enough in a case where most of the reason for self-defense, not all of it because he reaches, but most of it is the awful words that the victim's saying?
No, I think it's illogical to take the position of, I'm going to argue reasonable provocation clearly as my primary defense in closing. I'm going to mention self-defense, but I know I don't have self-defense. And the reason that I know I don't have self-defense is because the defendant's testimony does not support self-defense. Because at no point does Mr. Henderson say, I'm shooting at this person because I'm trying to survive. He doesn't say that. He says, I shoot him because I'm on autopilot. Autopilot is the exact opposite of self-defense. Trial
It's kind
counsel,
of the opposite of passion, I would think, too, right?
I'm sorry?
I would think it's also the opposite of passion.
No, it's
Sort of a flat line, autopilot. That's how I see it or hear it.
Autopilot, what Mr. Henderson is trying to describe is a state of no intent, a state of no malice. That is, and that essentially is what you're doing. You're so overcome by emotion, you're so overcome by fear, fright, nervous excitement, that you don't have intent, you don't have malice. You are on autopilot. You're not thinking. That is reasonable provocation.
He doesn't say that when he saw the lifting of the shirt, that's what caused him to react out of fear or some other emotion.
Again, I think, we have to view the evidence in the light most favorable to Mr. Henderson. Mr. Henderson doesn't pull out his gun and shoot during the statements that are being made to him. It's only once that motion is made. And that is why the court said he was entitled to a self-defense instruction. It's also why he's entitled to reasonable provocation. I mean, this case is
I
very
thought you said he
similar to
wasn't
Little.
entitled to a self-defense instruction.
I'm sorry?
I thought you said he wasn't entitled to a self-defense instruction.
Based upon his testimony, I think that it was a very close call. I think he was much more entitled to reasonable provocation than he was to self-defense. I think that trial counsel correctly argued what Mr. Henderson testified his state of mind was, which was that he reacted. He did not intend to kill. There was no malice. That's what Mr. Henderson testified to. That's what trial counsel argued. And the reason for that is because this was a reasonable provocation case. Trial counsel says as much in his testimony before the court. This was reasonable provocation. I screwed up. I argued it to the jury. I asked them to do something that they couldn't do because I didn't ask for the instruction, which would have allowed them to do what I was asking them to do. That's
Counselor,
completely illogical.
I don't want
There's
to-
no strategy there.
I don't want to bury the lead, but I do have one question on the post-arrest silence issue, which is, how is it preserved?
At the beginning, trial counsel did object, and
Well, he objected on the first detective, but on the mention of the attorney. He didn't say anything about post-arrest silence that I saw. Am I missing something?
I'm sorry, say that again?
He objected about the mention of an attorney in the statement, but I didn't see anywhere where he said this was a statement on post-arrest silence or objected to it in general, and then there was no objection on the second detective. Am I missing something?
No, there's no objection on the second detective. Our contention is that it was preserved by virtue of the first objection, which the court did go on and give an instruction and discuss this, that there was no, there's no requirement for somebody to make, a statement. And so I would say that objection, that instruction did preserve the issue. It was clear to counsel at that point that any further objection on that point would have been futile. So I believe that at that point the issue was preserved. Even had it not been, this is clearly an instance where Mr. Henderson's constitutional rights were violated, and it would meet the standard even if it was unobjected to. But our contention is that it was. I see that I'm over my time. If there's any other questions.
Well said. Thank you.
Thank you, counsel.
Thank you.
Good morning, and may it please the court. Brooke Hartley for the Commonwealth, and with me at council table is Assistant District Attorney Sarah McAvoy, who is one of the trial prosecutors in this case. This court should affirm the defendant's conviction and the order denying his motion for new trial, beginning first with the denial of his motion for new trial. Even if the defendant was entitled to a reasonable provocation instruction, which he was not, but even if he was, it would have been a reasonable tactical decision not to request one, where this would have interfered with the far stronger claim of self-defense. And I think we already hashed this out, but this was a strategic decision demonstrated by counsel's testimony at the hearing, and the motion judge found as much. Considering that it was a strategic decision, this court must determine whether it was not manifestly unreasonable. And it was not manifestly unreasonable for 3 reasons. Essentially the same reasons that
Can I just slow you for a second? So
Yes.
can we move beyond then, he wasn't entitled to the instruction on reasonable provocation? Seems a
Sure,
bit
the
of a
Commonwealth
stretch of an
contends
argument
that
to
he
me.
was not entitled to the instruction, and I can elaborate on why, but I don't think the court necessarily needs to go there. If you look at Glover, the court said that he actually was entitled to both, but it was still a reasonable tactical decision. So I think we can start there. And the reasons why this is not a manifestly unreasonable tactical decision is for essentially the same 3 reasons that are outlined in Glover. That is, he was pursuing a full acquittal, an all-or-nothing strategy. And I can go through them in more detail, but first I'll just list them. Second, even if counsel would have argued both theories, reasonable provocation would have diminished the self-defense claim in the eyes of the jury. And third, reasonable provocation was weak at best.
So Glover doesn't say weak, it says that self-defense is stronger. So your friend obviously disagrees that self-defense was stronger than provocation. Could you explain to us why it was stronger, if that's what you think?
Explain why self-defense
Self-defense
was stronger.
not just reasonable provocation was weak, but why was self-defense stronger?
Sure, absolutely. So I think when when you're considering reasonable provocation, the court looks at the entire context of the circumstances. But reasonable provocation itself is about a moment in time. It's sudden. You can't slowly lose control or have a heat of passion over time. That is a calculus of survival, and that is detailed in Vinton. And that's what we have here. And a calculus of survival can be self-defense, whereas heat of passion cannot be.
What about if he argued, well, he was, it was a slow burn, but when they mentioned, I'm going to find your family and, you're going to hunt down your family and kill you and anybody who's with you, that's when he snapped. And that's where it went. Because that was
Sure.
pretty close in time to when he pulled out and started firing.
Sure, Your Honor. I think that's certainly part of it, but you also have a history of a relationship and words that have been uttered, not just now, but many times before. And I think you also have to look at what happened. He brought a gun to the scene. If you look at Commonwealth v. Gouette, that's appeals court case 66 Mass Appeals Court 633, where the court said that he was not entitled to reasonable provocation because he brought a gun to the scene. And the facts were perhaps more egregious than you have here. He sort of planned an altercation where he brought a gun to defendant's house, a loaded firearm. He said it was because he was anticipating a need for protection, but ultimately when he saw the defendant, actually, I'm sorry, I'm confusing Gouette with Benson, which is a sort of similar case. But this Gouette was a case where the victim owed the defendant $20, and he went to sort of go settle the dispute. He brought a gun. When he gets there, the victim's brother smashes his window, and at that time he starts firing. So if anything, those facts might actually be stronger. There's an act of violence by the victim that then provokes him to shoot, but because he brought a gun to the scene, the court says that is evidence.
How is self-defense stronger when his testimony was, once he saw the lifting motion, the shirt lifting motion, that he shot because he was on autopilot?
So I think you still have to look at the entirety of the defendant's action, or the relationship in the context of everything that happened. And I also think if you look at his actions after the shooting, after killing the defendant, which is something that the Supreme Judicial Court says can be evidence of emotional state having to do with reasonable provocation, after the killing. In Glover, the defendant said something to the effect of better him than me, and then I figured I'd get him before he got me. He also told someone that he moved back after he stabbed the victim so that blood didn't get on him. In this case, you have the defendant testimony. The defendant was trotting away as if he were trying to catch up with friends, motioning for people to get inside, and then fleeing. I would argue that these actions immediately following the shooting reflect a presence of mind that is inconsistent with reasonable provocation, but could be consistent with self-defense. Again, I think it's a calculus of survival that you have here that has built up over time and certainly culminates with seeing the victim reach to his waistband after uttering words to the effect of, if I wanted you dead, you'd be dead, and threatening his family. I also think you can look at the defendant's own testimony. He said, or excuse me, this is on cross, but the Commonwealth asked, there was nothing preventing you from walking away, was there? And he says, he threatened my household. The prosecutor asked, he threatened your household and you needed to do something about that, didn't you? If I couldn't protect my kids, who will? Those statements don't suggest reasonable provocation. Again, they suggest a calculus of survival that is consistent with self-defense.
So why would it be unreasonable to argue both? Why would it not be?
Manifestly unreasonable to not argue? Oh, that's a lot of negatives there.
Couldn't counsel have argued in the alternative?
So the Commonwealth's position is no, because the instruction was not warranted here. But even if he could have argued both, that does not mean it was manifestly unreasonable to pursue one strategy and not the other.
Why would it have undercut self-defense had he requested the instruction on
I think
reasonable
for the
provocation?
reason counsel states at the motion hearing, which is his concern about the mere words language. Mere words, no matter how insulting or abusive, do not ordinarily by themselves constitute reasonable provocation. His concern was that that instruction would have diluted his strategy where words were critical to the self-defense argument. The defendant reaching to his belt alone without the context of this relationship that was mostly consisting of words, the victim stalking the defendant, making threats to the defendant, both himself and through his friends, were crucial to the self-defense argument. So to put in front of the jury that these words might not carry that much weight could have undermined that strategy. And that is a reasonable tactical decision. I think we have to remember that we're essentially searching for rationality in counsel's strategic decisions here. We can't look at it with hindsight, and certainly counsel may have testified at the motion hearing that, I'm reading your brief, and perhaps props to appellate counsel. I think he may have convinced him with his brief that he should have pursued a different strategy, but that doesn't mean that it was manifestly unreasonable at the time it was made. So
a bit of a smaller point, to be sure, but in terms of going to get his gun or bringing his gun to the conversation, assume for the moment again that there's no issue with the excited utterance portion of the Buckmeyer-James testimony that he saw the defendant go inside the house to grab a firearm. How is that not utterly speculative as to what he was doing? He went into the house and he came out.
I think it's a reasonable inference based on what he saw. And again, I don't...
Well, so he had the gun with him the whole time, as he always carries a gun around. Why is that a reasonable inference that he went into the house to get a gun?
Well, I think there was testimony about what he did previously that day. He took his daughter with his girlfriend to the grocery store, and it may have been reasonable to consider that he wasn't carrying a gun. I think to the doctor's office he may have gone, that he wasn't carrying a gun on him all the time for those things. It's also, that's fodder for
I don't understand this. Buckmeyer-Jones isn't making a closing argument. He doesn't get to make reasonable inferences, right? He just gets to tell you what he saw.
Sure, that's true. And what he saw was reaching to his waistband, and it comes in as an excited utterance through the officer. So Buckmeyer-James does not testify that he thought he had a gun. He testifies that he saw him reaching towards his waistband and he thought that was a red flag. And I think the officer the excited utterance can come in through the officer, and the weight of that is something for cross-examination. Defense counsel was certainly entitled to unravel that and point out that he didn't actually see a gun. All he saw was him reaching towards his waistband. If your honors have no further questions about the reasonable provocation, self-defense portion of this, I can move on to the next issue.
You argue one of the reasons why it was reasonable to focus on self-defense is because of the probation proceeding.
Yes.
But would it have made a difference, an acquittal, given that there were the 2 firearms charges?
It was an all. So I think it may not have made a difference. I think that any conviction would have triggered the probationary sentence. That's true, Your Honor. But I think it's
And there's
still...
nothing in the record that would suggest there's a greater or lesser likelihood that someone is going to get sentenced to the minimum mandatory 20 if they're convicted of manslaughter as opposed to a firearms charge.
There's
I mean,
there's nothing in the record.
Speculate about that, but there's nothing in the record that would...
There's nothing in the record that I recall, Your Honor, in regard to that.
I mean, there's no defense to the firearm carrying, right?
There's no defense to the firearm carry, yeah. Ultimately, when he pursued self-defense rather than identification defense, yeah. And I would also just point, since this was touched on earlier, and counsel argued that the defendant's closing, the trial counsel's closing was self-defense, not reasonable provocation, not self-defense. I think there are several points in the closing where he explicitly argues reasonable self-defense, which is, again, talking about the entirety of the situation. He talks about on volume 6, 21, this wasn't all in a vacuum. This shooting wasn't in a vacuum. Mr. Brown was threatened by my client. He had been in several fights, sending people over to fight with him. My client had observed firearms with him in the past. So these things are all in his head at the time of the fatal shooting. I think this does not go to reasonable provocation. This goes to self-defense, and there's several other statements to the like in his closing. Moving on to whether trial counsel was ineffective for failing to elicit particular evidence, I will just take them in order unless unless Your Honor has specific questions. Or I do see that I only have 2 minutes. I can also move to the post-arrest silence issue, if that would better serve the court.
Do you think the objection is preserved?
Post-arrest silence. So I would just note for Your Honors that this was the subject of a motion in Lemaine, and I think that context is particularly important here, perhaps as to whether it was objected to. I agree with counsel that there's an objection on the record and then a curative instruction as to the detective.
Oh, I missed the motion in limine. What did it say?
So the motion in Lemaine, it's on page 60. The testimony about it is on page 60 of the that hearing, and it's defendant's motion to exclude.
Of the motion limine hearing?
What's that?
When you say that hearing, you mean the motion limine hearing?
Yes, the motion limine hearing, and it's defendant's motion to exclude his request to remain silent and to consult with counsel. So what happens is the Commonwealth agrees not to comment on his request to remain silent and to consult with counsel, but explains that after the defendant was arrested in Alabama in 2018, the detectives went down to see if they could get a statement from him. And immediately when they walked into the room, he asserted his rights, and they didn't ask him any questions. Because they weren't planning on asking him any further questions, they didn't Mirandize him at that time. But while he was waiting to be taken back to his cell, he started asking the detectives questions, and the Commonwealth sought to introduce those comments. So really, the Commonwealth was not commenting on his post-arrest silence, but was eliciting the defendant's own comments to detectives, which were to the effect of, look into my 2008 case. Can you look into this? Did you look into this? And what the testimony was at trial, both through Detective Ruiz and through Detective Siegel and through the defendant's own testimony, was an explanation of those statements and an explanation that police did look into that and did investigate, and ultimately came up with nothing. So I think this was something that was crucial to the defendant's defense. He immediately in opening brings up this 2008 case. He's very concerned about, not being viewed as a snitch. And it was important that the Commonwealth explain that police did look into this and explain the situation. Otherwise, the jury potentially could have been left with the impression that the police didn't do a complete investigation.
Counselor, I have one final question. If we reverse on the reasonable provocation, would the Commonwealth prefer a new trial or a reduction to manslaughter?
Your Honor, that's a question that I would need to discuss with not only trial counsel but my supervisors. So I would be happy to submit a 16L to the court, but I can't answer that just yet.
All right, thank you. Thank you both. The case is submitted.
Thank you, Your Honors.
Okay, we'll hear the last case, which is, let me get it, MJ versus Bridgewater State Hospital, number 2023 P732. And this case is impounded, so please avoid using the parties' names.
Up. Good morning, still, I think. May it please the court, Kara Shayette for the appellant MJ in this consolidated appeal. So this case raises 3 questions under Chapter 123. First, with respect to 17A, Did the clinician's opinion that MJ had been restored to competency have an effect on the validity of MJ's 16B commitment? 2, with respect to 9B, did the Plymouth court have any authority to make any determination or even consider the question of MJ's competency? And 3, with respect to 18A, what language in that provision authorized Bridgewater to file its 18A commitment, petition for commitment? And so I'll turn right to the 17A question, unless you would just like that timeline, sort of the 5 dates on which the various provisions were invoked. If you don't need that, I'll move right to 17A. You're good.
I think you can move on.
Good. So the plain language of 17A says that a finding that the individual has been restored to competency does in fact terminate the 16B commitment. And a footnote, I just want to acknowledge that my judicial estoppel argument in the reply just was wrong. I got caught on a lane and I didn't go back to the statute, so that's neither here nor there. Thank you. So if a finding terminates a 16B, but an opinion isn't a finding, even a shared opinion isn't a finding. So I don't think I need to belabor the point that,
So your point is the judge in Plymouth had no jurisdiction over that determination?
well, so I think just it can be, depending on how you think about this case, it seems so overly complicated. But so 17A says nothing about commitment, and then we can get to 9B, which says nothing about competency, right? So 17A, that opinion had no effect. And I don't want to belabor the point, but Foss...
Well, it's not that it had no effect. Once the opinion comes, the guy has to be sent back to Suffolk for a competency determination.
Well, right, but so what the statute says is that once Bridgewater develops the opinion that the individual has been restored to competency, it has to alert the criminal court, and then the criminal court, without delay, has to hold a hearing. But bear in mind, in terms of that timeline, they filed their 17A revised opinion along with the 18A petition on December 8th, and the hearing on the 9B is December 9th, so it's the next day. And 9B...
So assume for the moment that I'm with you on the judge didn't do a 9B hearing because it didn't address the 2 requirements of 9B.
Right.
Right. And competence, as you say, had nothing to do with 9B.
Right.
Okay. Why does the judge not have discretion where the statute requires the judge to act promptly? If you looked at other parts of that, of 9B and other parts of 123, there are days that are required, there are some places immediacy. That simply says promptly. So why can't the judge say, well, seems to me promptly is after they figure out the 18A up in Suffolk Superior, which is really the people who have control over this case anyway. And it's going to be a week or thereabouts. Tells the clerk, why don't you call the clerk up in Suffolk and tell them, let's get going on this because they have this 9B down here. Why is that not within the judge's discretion to do that?
Well, I think...
That's not exactly what he did. It's pretty much what he did.
So first of all, the mandate under 17A to without delay hold a hearing is talking to a different court. So the without delay language in 17A isn't talking to Plymouth, it's talking to Suffolk.
Right.
And so he's not bound by that. But at that point, everyone's in court. I mean, I think that does a judge have the discretion to act without the authority of the statute? I don't think so. And I think if I'm reading, I don't know if you're asking the question of how was he harmed by this? Didn't he sort of get what he was looking for, which was a hearing on his commitment? I don't know if that's...
No, I guess what I'm saying is as a practical matter, the judge did not address the 9B. He said, okay, you folks agree he's competent, go up and do the 18. Well, I'll say he's off the 16B, which he really didn't have jurisdiction to do, okay? But so as a practical matter, the judge took no action under 9B. Mm-hmm. And 9B says, the justice within 7 days shall notice the time, and then a hearing shall be given promptly.
Right.
Promptly, it seems to me, is a word that can be interpreted as next week, 3 weeks, a month from now, depends on my schedule, depends on my docket, depends on whatever else is going on with this case. that there are a lot of different factors the judge has to look at and say, do I want to hold a full-out hearing on a case that I really have no connection to and I otherwise wouldn't touch, and I'm required to do this promptly, but if in the meantime I send it over to Suffolk, whose case it is, and they deal with it, doesn't that make a whole lot more sense?
So, one, the 9B petition was filed on November 14th.
Right.
We're now on December 9th.
In
And
fairness, that was because
well, because they
respondent requested a
They wanted an
continuance.
IME, absolutely, but that doesn't mean, I don't think that
We want an IME.
he'd wanted an IME to have that independent evaluation. And so I'm not sure I can answer your question, because I think, well, of course, he had an obligation and MJ had a right to be heard on this 9B. I don't think it's sort of, well, we can hold it or we don't hold it, because if in fact he met his burden beyond just a preponderance of the evidence, which is, I think of like a skirmish. I don't know soccer or football, but it's sort of like he goes into court knowing that all he's got to do is kick that ball over the midline, right? As opposed to Bridgewater wants this to be, you're the goalie and the entire government's team is coming at you and you're protected, because it's the beyond a reasonable doubt. In the 18A, it's just a preponderance of the evidence by the 9B.
It's more favorable to him in the 18A, right?
Well, I know that you can sort of, as a technical matter, I mean, that's certainly one of Bridgewater's arguments at the 9B. He's in a better strategic position if he's a respondent.
How do you, let's say the Plymouth judge adjudicated the 9B and found against your client. You'd still have to litigate the 18A, right?
Well, no, because then they would be in Suffolk. The 16B would be terminated.
And committed, the parties would still have had to litigate the 18A because the burdens are different in the 9B and the 18A.
So
the hospital will still have to meet its burden on the 18A.
So we have to get to the 18A because of the question whether it's a valid petition. Yeah. But so let's just follow this. What happens under different findings by the 9B if there's an actual hearing? So say MJ doesn't meet his burden. He remains committed in Bridgewater under the 16B. They go to the criminal court, and if the court finds that he's no longer incompetent, then the 16B is gone, and now there's a question whether Bridgewater's going to file a petition. I would submit under, whether it's a 7 and 8. I don't think it becomes an 18, but there's that moment.
Assuming the 18A petition is procedurally proper for now, an adverse ruling against your client on the 9B would not be preclusive in the 18A, right? They'd still have to meet their burden on the 18A to keep him committed. They can't say because he lost on the 9B, he should stay committed.
Well, but since the opinion of his competency didn't invalidate the 16B, on that Friday, December 9th, if he had lost the 9B, he would have gone to bed that night in Bridgewater and stayed committed properly under 16B until there's the 17A commitment, at which point there could have been a 7 and 8 if he was remanded to Nashua. There might have been an 18A. So there may well be, it looks like Bridgewater did not believe this guy should be released from a mental health commitment. So if he'd lost on the 9B, it's highly likely that there would have been some proceeding. What that looks like.
I'm asking, if he lost on the 9B, Bridgewater would not be able to use that for its preclusive effect.
Yes.
Because they'd have to meet their burden on their own petition. So there was the possibility for mostly duplicative hearings if the Plymouth judge ruled against your client. So let's say what the Plymouth judge did instead was say, I'm going to stay my decision, any decision on the 9B while this all plays out in Suffolk Superior. Would that have been an error?
Yes, actually, because he would not have been permitted to bring a 9B petition for discharge immediately on the heels of a newly ordered commitment. The rules say you have to give time after you've been committed before you can bring a 9B. That's one of the things here. He didn't challenge his 16B commitment. He waited an appropriate period of time for the possibility that circumstances had changed such that he no longer met the commitment criteria. So if then there's a new commitment under a different provision after the 16B is terminated because he's now competent, now he's back in a bind where that 9B never gets committed. And if we can just discuss what happens if he wins. If he wins on the 9B, then that night he's sleeping in a jail cell at Nashua Street, and I mean, he's not going out in the street.
Let me ask you, given another hypothetical. Say your client is not as he was, but is floridly psychotic, and then he wins his 9B and they ship him off to the Nashua Street Jail. Does that make sense at all within the construct of this statute, the legislative intent on 18A? And it just doesn't seem to me that that makes any sense whatsoever.
If my guy had been floridly psychotic, this case might look very different. But
But
once
if we're coming up with rules as to how we apply 123 and whether in fact, so let's move on to 18A, whether in fact Bridgewater State Hospital is a place of detention, and whether they have statutory authority to file an 18A petition, I think we have to think of all those things. So let me change it up a little bit then and ask, right, the statute doesn't say jail, house of correction, or prison. It says a place of detention, which we now understand is a local police department lockup. It's actually a courthouse, to the extent they all have lockups. Why is Bridgewater State Hospital not a place of detention?
I just
Sure.
just think in terms of all of these statutes, 18A included, have to be strictly construed, toward not being involuntarily hospitalized. So
Right.
in pages 6 and 7 of my reply brief, I busted 18A out because it's just a beast of a provision. So
Put
it's-
everything into A. They sure do. Yes.
So there are 8 sentences, and you have to be a little bit of a detective. Let's look at what Bridgewater claimed as the language within 18A that authorized
Before you jump
it.
into that, this petition says 18A on the top,
Right.
but if it said 7 or 8 on the top, would it be any different other than not having something about him being held?
Well, so every door through which somebody ends up involuntarily committed has its own prerequisites. There's sort of a marriage between petitioner and respondent, or a circumstance in which the respondent finds himself vis-a-vis the petitioner.
But would it have been any different with a 7 or 8
Well, so at the moment,
standard, the hearing, right?
well, again, I sort of come back to the 17A opinion, since at the time it filed its petition for commitment, MJ remained committed under a valid 16B, and it wasn't going to terminate for another month or so. Of what legal consequence was a petition filed during the pendency
But so you're
of this
saying
commitment?
Bridgewater couldn't have filed an 8. They couldn't have said, this guy is competent now, so we're done with that, but we know he needs to be committed. We're going to file an 8?
Well, so again, not until the 16B has actually been vacated by the criminal court. Again, right, we're not.
Well, but then we're back to Justice Brennan's grossly psychotic person. Apparently, and that's what you're saying there, that person would have to be sent back to the criminal court, the 16 would be vacated, that person would have to be put in Nashua Street for a day until he acts up there, and then start the 18. I don't know why Bridgewater couldn't do an 8 on someone who's under a 16. What says you can't do that?
I think that they may, under other circumstances, I suppose, the big, in that hypothetical, the elephant in the room is that he had a right to a hearing on his 9B. Everyone is in the courtroom. Why deny him the opportunity if he's floridly psychotic, he's not going to be
Because
released?
it's all has to be redone in a week anyhow. Isn't that why you don't generally want to do a hearing in Superior Court that has to be redone in a week?
But, there's a couple things. We don't know, the criminal court could have rejected, wouldn't have been bound by stipulations that he was incompetent, right?
For
And
sure.
then in the criminal court, you've got the DA who's going to weigh in, you've got the criminal defense attorney. There are a lot of other parties in that court. But I know I'm repeating myself, but it doesn't mean that you can just look past the 9B just because Bridgewater filed this other petition. And I know the time's up, but I really would
Can
like
I
to
ask
get
one
to
other
this
question on that, though? Because
18A.
we're asking a question, a little extra time. But the DA still had time if they wished to weigh in on a 16E, right?
Well, I don't know that 16E was invoked because Bridgewater wasn't claiming that they were going to discharge him. They were fighting the discharge.
They did send the 16E letter, right?
They did send it, but I'm not sure under what authority. But can I address a little bit of the 18A question? Because it is.
Sure.
I appreciate that. So they can't be, why are they not a place of detention? In part because people that are housed at Bridgewater are patients. They're not prisoners. And so there's that. They're always patients. They're not prisoners. And second, you can't be the sending and the receiving institution. I mean, the whole concept of the start of 18A sentences 1 and 2 is sort of having somebody observed and evaluated within the place of detention and then reported to the court, which will then send the individual to Bridgewater. But in their papers, at our pages, in their motion 19, RA 19 and 25, Bridgewater points to the second sentence of 18A as the authority for the filing.
The seventh sentence?
So RA 19 and 25, that's the Bridgewater's emergency motion to dismiss the 9B, and their cover letter to Suffolk says, we have authority to file this because the second sentence requires that if a prisoner is awaiting trial, that internal evaluation by a clinician in the place of detention has to send a report to the court. Bridgewater sort of strategically uses brackets and says that second sentence requires, it to send the petition to the court. So there's that. So then you go through the rest of 18A. There's the evaluation by Bridgewater, and it's in the sixth sentence of 18A that Bridgewater's authority to file under 18A ripens. And in looking really hard at the supplemental record appendix that Bridgewater filed and its brief, it doesn't come out and say it, but I gather that they view that their authority to file this 18A was based on the 18A that had been filed in this case a year earlier. And I don't want to confuse things more, but I was watching Maine's. I know there's a case under advisement where there's sort of a question of at what point, it seemed to me it's sort of like the hand out of the grave. It can't be that Bridgewater in perpetuity can look past through an intervening 16B commitment and invoke its authority deep in 18A to file a new commitment under 18A.
Why not? So the seventh sentence of 18A says the person in charge of the place of detention shall have the same right as the medical director of Bridgewater to file a petition. What is this talking about when it says right, the same right? Where does that right come from?
At the point that sentence would come alive is after place of detention refers to...
You're saying the first 6 sentences have to be satisfied.
Yes.
So when that was done a year before...
Yes.
Why hasn't their right to file a petition ripened?
Because first of all, we don't know, and in that regard, I don't know that you can escape the facts that were put on the record at the 18A. And I appreciate the court's going to be issuing a rule that governs other cases. But we had somebody whose mental illness was in remission, he was working in the kitchen, all of that. The question
I guess I'm
was
not
his insight.
understanding why it mattered. Why aren't the first 6 sentences more of the mechanism by which a place of detention brings a person who they believe is in need of treatment to the attention of the court? Why does it otherwise really make a difference, whether it happened in 2021 versus more recently?
Well, because I'm beyond repeating, I mean, where there's an intervening commitment with a different set of facts under different circumstances, I don't know that you can, so at what point...
Why does it matter if they still have to meet their burden on the petition?
Because the condition precedent for an 18A petition, I mean, that's the door that the legislature has labeled for those
Right,
people who are...
to set out a mechanism to bring a person to the attention of the court so that they can be transferred from the place of detention to Bridgewater.
Right. But having been brought to the attention of the court in early 2021 that MJ was, worried that his food was poisoned and he was having difficulty, a year and a half later, that earlier difficulty in Nashua Street Jail, I think is where he was, that somehow that then justifies all of this. And again, some of these principles.
Can I try Judge Shin's statutory question again, because I didn't understand your answer. The person in charge of the place of detention shall have the same right as the superintendent of facility and the medical director of Bridgewater State Hospital to file a petition, which suggests that there is some ability of the medical director to file a petition. What's that ability that the facility has?
Absolutely, to file a petition if you're in that process of 18A. If that's a 7 and 8 can only be filed by Bridgewater if the individual's already there. So if you
you're saying that the head of a place of detention can file a 7 or 8 under this sentence?
No, it's that Bridgewater, I absolutely agree that Bridgewater, there is an authority under 18A for Bridgewater to file a petition, but the circumstances are particular to the person having at some time, and certainly not with an intervening commitment under a different provision of the statute, if there had been no 16B, I didn't think sort of what would my argument be, but we have this intervening circumstance and a 9B validly brought that circumstances have changed. I don't know that all of that, I see you scratching your head.
No, I guess my thought is the overarching purpose of 18 is to get folks who are mentally ill and need hospitalization out of penal or exclusively custodial places so they can get treatment. So it just seems to me that how you're asking us to interpret this statute just undermines the legislative purpose, and to the extent that someone's right there in Bridgewater, them being able to file a petition and say, this guy really should stay. I don't think he should go back for 1 day, 2 days, 1 minute to a jail or a house of correction. Why that's a problem legally. I don't see it.
So is the concern that if he had prevailed on his 9B and then he's remanded to Nashua and then he falls apart and then there's this restarting of this process, why is that necessary? I don't know that you can just say, again, I think the importance of the right to a 9B hearing.
No, you're putting aside the 9B.
Sorry.
Putting aside the 9B, you're reading 18A to require for the first 6 steps to be started all over again, because it happened back in 2021. And why does that make sense? So he has to be returned to the jail so that then the jail can report him again to the court. So you have to start this all over, and you're saying that only when that's satisfied is the right of Bridgewater to file a petition triggered. But let's say the initial 18A was adjudicated, the one they filed back in 2022, and the court...
in 21? The first
I believe
one?
they filed in late 2021, early 2022. Let's say the court adjudicated that and issued a commitment order, and he goes in under 18A. Bridgewater would then have the authority under 18A to file petitions to recommit him, right?
Yes.
So why does the intervening 16B matter?
Well, partly because the 16B is predicated on him being both, a criminal defendant, mentally ill,
I understand,
and
but
incompetent.
as a matter of legislative intent, why should the fact that in the intervening time he was committed under 16B matter? You're saying that he has to be returned to the place of detention so that this whole process has to start all over again. Why does that make sense?
Well, in part because what you're suggesting, Justice Shin, I think would require this 16C to say if an individual has been restored to, I think it's under 16, that if the individual has been restored, that's under 17A, that if the individual has been restored to competency, The statute doesn't say then that pending 16B converts to an 18A. It doesn't say anything like that. And I just think that I do hear the court's concern for judicial economy, but these provisions set
It's
forth.
also for the protection of folks who are mentally ill and within our criminal justice system who are committed in some sense, who are held or committed, and it seems to me that 123.18 is there to protect those people, and if we're taking a mechanism of protection away from Bridgewater, which is tasked with at least theoretically protecting them in a secure environment, it doesn't make sense to me.
Well, their job was to, in this case, was to restore him to competency, which they did. But I do think that you're assuming that he would have just lost his 9B like that. We don't know that he wouldn't have been able to be remanded to Nashua and then proceeded with the criminal case.
Okay,
I mean,
you're well over time. Let me just see
Yes.
if there are any more questions. So
All
I
right.
think we'll have to leave it there, and Attorney Conlon will
Thank
give
you so
you
much.
the same amount of time.
Finders keepers.
May it please the court, my name is Robert Conlon. I represent the Bridgewater State Hospital in connection with this appeal. I would ask the court to affirm the decisions of the lower courts in this consolidated case, namely the decision of the Plymouth Superior Court allowing MJ's 9B appeal, and as well as the Suffolk Superior Court allowing the 18 petition that followed a week later on December 16th. I wanted to note that basically this case concerns a mentally ill detainee awaiting trial in the Superior Court, and he came to Bridgewater from the Superior Court on an evaluation for his competence to stand trial. He was awaiting trial on trafficking charges, had a custody status. And what needs to be remembered in terms of the presentation of a mentally ill person who's incompetent to stand trial and comes to Bridgewater is that there's a liberty interest involved here. And in the matter of EC 479 Mass 113-119, the court takes pains to point out, and I point this out in my brief at page 33, in the case of an incompetent defendant, the government has a compelling interest in determining whether the individual may be returned to competency and thereafter be tried as competent. And the individual, too, has a compelling interest in not being tried if incompetent. Now, this is where Section 17A becomes very important, Your Honors, because basically in the case of MJ, he came to Bridgewater, he was treated, he got on medications. 5 months after he got to Bridgewater, the medications had started to take effect. He was improving. He filed a 9B petition in November of 2021. The hearing on that was delayed when he exercised his right to request an IME for his evaluation to presumably strengthen his case. But I would note, Your Honor, and I think 17A is the stronger argument I'll have, which again, I'll go over the language in a second, but
Can you just, if you wouldn't mind, just address the 9B briefly? Because again, as I read 9B, the questions are mental illness and strict security. Those are the two issues, right?
that's correct.
And the judge kind of called together, well, you say he's competent, you say he's competent, we can stipulate to competent, let's move on. But competent has nothing to do with 9B.
Well,
Fair?
what I wanted to point out, Your Honor, is that basically I think the lower court was correct in the way they handled this case for a number of reasons. The first is...
Okay, I may agree with you it's a kind of
Right.
broader concept, but in terms of the 9B itself, and it says allowed on it, but then it also, the one of which I'm not sure is appropriate either, because the 9B petition seeks, I think, finding of competency, which it's just
Right.
the whole thing. But how is that actually allowing the 9B if you do it on grounds that are not part of 9B?
Well, Your Honor, I would point to the pleadings in the case. MJ had filed his application, and in paragraph 4 of his application, he pled that he's now competent to stand trial, so he should be sent to the House of Correction. What MJ did in his uninformed way was to essentially reiterate the mandatory aspects of 17A, which are, if the Bridgewater now considers a person competent to stand trial in their assessment, that section requires that they shall contact the court and the person shall be returned to the criminal court without delay in order to address the criminal matter. And this gets back to the aspects of EC, where we hear how important it is that a person be brought back to competence and they be able to accentuate their liberty interest by being able to attend to the criminal matter that's now facing them. The structure of the case seems to be, people seem to want to put these two sections in conflict, but they're not. They
Just
describe
which two sections, because we're dealing with about 4 or 5 of them here, so just be more specific, please.
Right. Well, in the sense that my position and the hospital's position is, Your Honor, is that when our expert does opine that MJ is now competent to stand trial, we are immediately in a different procedural footing. 17A now takes over. And 17A, by its very terms, is more, by just statutory interpretation, is more compelling than 9B, which, as you referred to earlier, the 9B hearing could have been stayed until this process is worked out. Perhaps he would go back to court and not be found.
It could have been stayed, but I don't see why it has to be. I don't know why a judge couldn't say, okay, looks like there's evidence that you're competent, so Suffolk's going to have to deal with that, and I'll make sure that happens without delay. But meanwhile, it's plain, I know this isn't our guy, this guy doesn't need to be held anymore, so I'm going to give him a 9B, and, he'll go to Nashua Street, and I'm sure that's what's going to happen there. Why couldn't a judge do that if they wanted to?
Well, I think what the lower court judge did, and I think a prudent judge would do, would be to realize the dynamic situation of this case. MJ, when he was sent to Bridgewater for his evaluation of his competence to stand trial, was very psychotic. He was suffering symptoms. His criminal defense attorney couldn't work with him. Sent to Bridgewater. He's evaluated. He begins treatment. We finally get an 8B treatment order in Chapter 123, Section 8B, Rogers order. He begins taking medications. He makes an improvement. Now we're on the cusp of him returning back to the Superior Court to address his criminal matter. And I would argue that a delay would be to put him back into a house of correction at that very vulnerable point. And particularly in the case of MJ, it was shown through the record below that he was very sensitive to taking medications. When he took his medications, he did well relatively quickly. He decompensated very quickly when he didn't take his medications.
I'm not following your point or your answer to my question.
Well, basically, I'm saying that 17A, without delay, means without delay, without taking a trip back to the House of Correction, with getting him back to the criminal court as soon as possible. And I would note, Your Honors, that to the degree that he was requesting a hearing, he did have a hearing 1 week later, based on the 18 petition Bridgewater had filed.
Well, are you suggesting that sending him back to Nashua Street would have delayed the Suffolk hearing?
I'm submitting, Your Honor, that...
I'm not following that. It would probably be easier to get him from Nashua Street to Pemberton than from Bridgewater.
That may be true, Your Honor, but where we're dealing with such finite time horizons here, MJ, in this case, got back to the Suffolk Superior Court within 1 week. So I would submit that there was, for administrative reasons, there was no reason to conduct the 9B, but also for statutory reasons, as I mentioned before. The judge correctly read 17A, saw that that was the path forward at that point, and that the sections are describe different procedural situations.
But all of this is because there is a pending 18A, right? Because let's say there was no pending 18A. So the case goes before the Plymouth judge on the 9B. Now, he knows there's going to be a 17A hearing at some point soon. At that point, in the future, if MJ is found competent, he would be, at that point, discharged from Bridgewater. But he is saying, at the time he filed the 9B, I should be discharged now, and he's saying that 7 days makes a difference in terms of my liberty. So wouldn't the judge then be obliged at that point to act on the 9B, on the merits of the 9B?
Well, Your Honor, this I would submit in terms of the facts in this record, where we have a hearing a week later and we see that...
No, but let's just assume there's no 18A petition pending. If he files a 9B, isn't the judge obliged to act on it if there's no pending 18A petition?
I would say, even under those circumstances, no, Your Honor, for this reason. I think 17A directs him to send him directly back to the criminal court. But also, in this case, we also have the aspect of Section 16E of Chapter 123, which gives the DA's office notice that MJ is on the point of perhaps being discharged because he's now competent to stand trial. You, District Attorney's Office, under Section 16E, have 30 days to file your own 16C petition. So the district attorney has an interest in further.
But irrespective of the competency proceeding, if he meets his burden under 9B, he's discharged, right?
That's correct, Your Honor, but as I argued, and I won't repeat myself, if he can meet the burden, yes, he would be discharged. But again, I think it gets not only to an administrative inconvenience, but it's also 17A.
Let me ask you this. If the Suffolk judge had decided at the December 16th, 2022 hearing that the respondent was fine, didn't need to be any mental health treatment, could he have discharged him from Bridgewater State Hospital?
Well, if I understood your question correctly, Justice, if he goes back to Suffolk and is found competent to stand trial,
Yep.
his 16B commitment expires at that point, and if the court maintained a custody status on him, he would be returned to the House of Correction at that point, yes.
Well, aren't you telling me that 16E says that you can't release the person for 30 days after the end of a 16, and that would be the day the 16 ended?
Well, there's a nuance to this, Your Honor, that you did catch me on, which is basically the 16E language usually is 30 days, or if the DA waives that time. And the usual practice is that when someone that we're now saying is competent to stand trial returns to the criminal court, the district attorney's office, unless they have profound concerns about competence, we usually waive the remainder of the time at that point because they too have an interest in the criminal case proceeding. So that's the way that sort of works out, and that was a very insightful question, to tell you the truth.
I do my best.
Basically, Your Honor, I did want to just emphasize that there's a liberty interest involved here by having MJ return to the criminal court as competent. That has been an attainment for this patient. To send him anywhere else along the way, I would argue would be destabilizing. I think the lower court was correct in the way they handled this situation.
Counsel, as a practical matter, how frequently, if you know, does Bridgewater file 18As? Is it every week? Is it 10 a week? Is it
Well, it's
20 a week? Or
it's quite common because what has been missing.
is it quite common?
Right, exactly. And I did want to note that in my Pelley's brief, I noted how MJ came to Bridgewater from a place of detention, the Suffolk House of Correction, came to Bridgewater on an 18A evaluation while his charges were in the BMC. He was later, indicted and a 15B issued from the Suffolk Superior Court. But what's important here is that we have a patient who's been committed to Bridgewater, and 18A permits the medical director of Bridgewater to petition for recommitment for now what would be a year term on the heels of a 16B commitment, we would argue. And the prudence of that is found in some of the questions that you were asking earlier, which is basically that mentally ill patients require ongoing care often. And 18A is the mechanism by which Bridgewater can seek those recommitments without, and it's not inconvenience, it's actually, it benefits the patient tremendously.
As a practical matter, how common is it for Bridgewater to file an 18A in this situation where someone's committed under 16 and then found to be competent, and Bridgewater seeks to continue to have him committed?
Well, it's very hard to give you a number or an estimate, but it's not uncommon, I'll say, and it's a regular practice because oftentimes you will have a patient who has made the gains for competence, but perhaps has a more risk of violence profile. Perhaps they're suicidal, perhaps they've done, perhaps they're awaiting trial on very serious charges such as murder and things like that. So while they've made improvements to competence, they still require Bridgewater's strict security. And that would be this type of situation where they have a custody status, ongoing danger to themselves or others, that we would file an 18 petition. And I would just emphasize the fact that administratively, as well as I think it's well within the law. I think the statute's quite clear that 18 contemplates recommitments for up to 1 year beyond.
It does, but, so what makes Bridgewater a place of detention within the meaning of 18A when it says that after the initial report is filed, the court can choose to send that person to Bridgewater? So if Bridgewater is the actual place of detention, how could they then be sent to Bridgewater?
I think we meet the definition, Your Honor, by virtue of having a structure. It's a structure geared towards holding people who have custody statuses. We also have qualified medical evaluators, such as Dr. Laniato in this case, who's a DFP, who are assessing the patients, aware of their forensic needs as well as their mental health needs. And so we meet the criteria of being able to assess patients, opine concerning their mental health, mental illness needs, and particularly their danger profile and where they should be housed.
I don't want to step on Justice Shin's question, but it seems to me that goes more to it being a hospital and having folks in its care than a place of detention where people are held in custody. So to the question of how do we arrive at Bridgewater, because I appreciate it's a hybrid on some level, right? It used to be all DOC, right? Outer rim, inner rim used to be all DOC.
Right, correct.
And now the outer rim's DOC and inner is DPH people?
There's a WellPath as a subcontractor.
Right.
Right. Well, we are a place of detention for the initial, initial commitment to people, because people come to us from the criminal courts. They don't come to us, people do not come straight to Bridgewater. So that's.
But if they're already there, to the question, if you're a place of detention within the meaning of 18A,
Right.
then it just seems like it's a little bit convoluted to say, well, they're a place of detention and you may have them go there to be evaluated and then take the reports. Well, they're already there. They're already done the reports. So is it just a,
Well, we are.
no offense to the legislature, bad statute or a good statute that couldn't possibly anticipate any and every permutation of the spectrum of mental health issues, or where are we on that?
Well, but by statute, I believe it's, I may misquote the section, I think it's 125, section 18 perhaps. We are a Department of Correction institution of medium security. So I would argue that would be the reason. Are there any other issues as to this?
Let me ask you the same question I asked your friend, which is this 18A petition, if it was an 8, how would it look different?
I'm sorry, Your Honor, I missed the question.
So I'm looking at the 18A petition for commitment, and if it was a 7 or 8, how would it look different?
It wouldn't, Your Honor. This is the features of Section 16 and Section 18, respectively. 16 concerns competence to stand trial or not guilty by reason of insanity. That's a predicate. 18 concerns custody status or sentence. But the core of both sections, Your Honors, are 7 and 8. 7 and 8.
Wouldn't you have to file that in district court?
Actually, the jurisdiction of an 18 for recommitment is the...
No, if you were to file a 7 petition.
Oh, no, but if it were strictly just a 7 and 8 petition without a predicate, Your Honor, a 7 and 8 can be filed both in district court as well as at Bridgewater. But essentially...
As well as what?
See, 7 and 8 petitions can be filed on patients. Well, a 7 and 8 petition, Your Honor, would be filed in the district court. But what I was trying to point out to the court was how 7 and 8 are sort of like the heart and soul of
Right,
these.
but there's no other statute other than 18A that would allow Bridgewater to file a petition in the court that has criminal jurisdiction, right? In this situation.
In this situation, yes, Your Honor. Yes, Your Honor. We
So
could not file a 7 and 8.
If 18A has to give Bridgewater that right, or else you don't have any authority to file a petition, right? In the criminal court.
Correct, Your Honor. Where we were now opining that he's competent to stand trial, we obviously can't find a 16C petition because his commitment was about to expire in January, I think, of 2023. But you're correct. Because he had a custody status, we were able to file an 18A in the court with criminal jurisdiction, which was the Suffolk Superior Court. So I think if I've gone over my time, I apologize for that.
Okay, thank you,
thank you very
counsel.
much.
Thank you both. The case is submitted. Thank you to our court officers, our clerk's office staff, our timekeeper, and we are in recess.
All rise.
stand recessed. It's very nice to meet you. Fellow Cambridge residents, though.